Good morning, everybody. Thank you so much for joining us for our February webinar, the month of love. We're doing it slightly different today in that we're not going to do a long intro to Marlon. He has been a co-host of our webinars before, so we'll skip that one. But all of Marlon's details will be shared in the chat function, as well as all the details of Jules's BackaBuddy. For those of you that have an interest in potentially donating to this worthy cause, please do reach out to us for some more information. And Advocate Ross Randall, the father of Jules, has indicated that he's more than happy to engage with anybody. He does apologize for not attending the session this morning, but unfortunately he is in court, and the High Court starts its matters from 10 o'clock in the morning. So unfortunately it was a little bit of bad timing. And then of course, if you do feel it upon yourself, you're more than welcome to share the links. We're going to add a copy of the video as well as the links to the BackaBuddy and to the Instagram page that Marlon mentioned on the recording of this video as well. So it's a 2 million rand mark that needs to be raised, and they're at around about 75%. I think it's 1.4 odd million rand. And if you just go and have a look at that BackaBuddy list, the amount of donations and the amount that have been donated is amazing. Anything from a couple of $100. I think somebody donated like $50, which is absolutely amazing, to,
500.
Yeah. And in dollars as well. And quite a few people have done it anonymously too. So it's really, really very, very, very good. All right, so we'll share that video a little bit later on, and we're going to make sure that we end at 11 o'clock on the dot for those of you that like to join Marina and Whist. And for those of you that are joining STBB's webinar this morning, unfortunately at the same time slot as us, but just a reminder that the session is recorded. So if you know of anybody that did attend that one as opposed to our one this morning, just remind them that they can catch a copy of this one's recording. All right, Marlon, you are co-host, so you're welcome to share on your side.
Okay. How does that look?
It's opening up. There we go. Gotcha.
Okay, so is it on? There we go. Presentation mode and all that. Let me just minimize. Okay. Firstly, so everyone can hear me. Zelinda, all good?
Perfect. Thank you.
Cool. So firstly, just want to thank you at the outset. First, it's always great to be a co-host with you, and it's more important, I think, in this instance, that you're being so altruistic in allowing for Ross Randall's family's tragic situation to come about. I've been there with him since the beginning. And as I mentioned earlier before we started recording, that I've known Ross almost 2 decades. He's been at the Cape Bar for 17 years. I was one of the first advocates to actually brief him, one of the first attorneys to brief him. And we've developed a friendship because he's the most selfless chap. He didn't want to go on this BackaBuddy thing, but somebody said, you've got to do it, because I don't care how rich you are, 2 million rand is a lot, even if you say it quickly. And it's going to take more than that, I believe, to get her right. And God willing, may she recover from this horrific cancer, a beautiful little 5-year-old girl. And, may all the positivity we get today continue and permeate to them and continually. Today's topic is actually pretty interesting, and it falls well within my purview, because invariably matters either come before CSOS and there are disputes. And there's a lovely little quote I'm going to read to you just now from a piece of legislation, a piece from a case law, which now effectively makes up what I want to talk about today. And oftentimes people have the misapprehension that it's got to go to CSOS. It's got to be a dispute dealt with it. Just like a matter has to go to a rental tribunal instead of a court. It's not true. So that myth must be dispelled very quickly. We're not going to go into what matters fall before CSOS. What we're going to talk about is matters that fall before the High Court and what you need to do, because we're expensive. Attorneys are expensive. We studied a long time to charge a lot. We've got huge overheads, and the longer it takes to get us on board, the more costly it may be. But even when you get us on board, if you don't do it correctly, it may end up costing the trustees a lot of money. So on that note, I'm going to start off with the introduction, and just thanks again to Zelinda and your amazing team for putting the presentation together. It makes it look very, very sexy and smart. So thanks for that. Just a quick quote. When you thrust into litigation, you obviously have to make sure you're prepared to deal with that. Litigation isn't for the faint of heart. Sometimes you have to do so. And in particular, if it is a matter that falls outside Section 39 of the Community Scheme Ombuds Act, it falls out of the realm of CSOS. So if you have a dispute, sectional title, HOA, share block, and you need to escalate it to a high court, you actually need to know what to do, how to prepare for it, and potentially what to expect, cost-wise and results-wise. And hopefully after this session, I'm locked in at an hour maximum, you're going to have the entree that you need to hopefully brief your attorney of choice, whomever that might be, for a matter that needs to go litigious. So just to briefly touch on it, and I'm going to mention that case just now, this misperception that you have to go to CSOS is not true. In fact, it's not actually decided in our law. There are quite a few cases which vary. And Zelinda, with your permission, if people want copies of these cases, I'm more than happy to circulate it. But there is no effective legal requirement that matters have to be referred to CSOS as opposed to approaching High Court. Courts obviously are alive to the CSOS Act. They're alive to the STMSA. They're alive to trustees wanting to find resolve before it becomes litigious. But that doesn't mean that the High Court is ousted from having the jurisdiction to deal with the matter. You may very well want a High Court judge or a magistrate's court magistrate pronouncing and giving a court order as opposed to a CSOS ruling. And I think one of the most important things, which I haven't mentioned in the notes, is that when it's a High Court matter, it creates what we call precedent. Whereas at CSOS, there may be a ruling on a matter, and you might find a similar matter which achieves a different ruling because there is no precedent as such. And again, I always bring in the rental tribunal because I do a lot of rental work for those of you that know me. The rental housing tribunal makes a ruling. It's not law. It doesn't have the power to make a law that you can rely upon if you bring a similar case before the tribunal. It doesn't create precedent. But with the rulings that we have in our courts, and I'll mention them quickly, it's the Manhattan Place Body Corporate, a famous case, Wingate Body Corporate, AgriWire versus Competition Commission, and Standard Bank, you will see a spectrum of views of when CSOS fits in. For example, the court said CSOS should be the first step. That was in the Manhattan case, unless there are exceptional circumstances. And of course, I'll make these cases available. Secondly, with the AgriWire case, the SCA said the court can't refuse a case being heard just because it could similarly be dealt with before the community scheme ombudsman. And then finally, the Standard Bank case confirmed that unless it's expressly ousted, unless it's expressly prevented from being the forum of your choice, the High Court still is the one that has competent jurisdiction, it has the ability to handle your matter, and it may be preferable. And there's one case which I haven't mentioned, and Zelinda, I'll make this note available. There's actually a case of Prague versus another versus trustees for the time being of the Mitchell's Plain Industrial Enterprises Sectional Title Scheme Body Corporate. And just one very small quote from that, which I think touches on exactly what we're talking about today. And it says the following: if one considers the terms of the CSOS Act as a whole, and the kinds of matters in respect of which an adjudicator can make orders in terms of Section 39 of the Act, they either concern regulatory governance issues pertaining to the administration of a sectional title scheme or behavioral issues pertaining to the conduct of members of the scheme. It was not intended that the Ombud would have the power to adjudicate on delictual claims for damages, which involve weighty considerations pertaining to wrongfulness and fault, and the quantification and determination of the quantum of any damages which may have been sustained pursuant thereto, which are matters best left for judicial officers and courts. In other words, just because we have the Rental Housing Tribunal to deal with unpaid rental and naughty landlords doesn't mean that the court can't deal with it. Similarly, just because CSOS can deal with a regulatory issue, it doesn't mean that it's the only forum. From personal experience, CSOS certainly has a role to play, which is exactly why when a matter like that arises, Zelinda is my first port of call. But sometimes, more often than not, it needs to go above the first step. In fact, it sometimes has to go beyond CSOS as opposed to going straight to the High Court. And I'll mention that very shortly. All right, so to determine if the High Court is the right forum, you've obviously got to look at the High Court as whether that is the jurisdictional forum that you want to be in. So look at the community scheme, look at Section 39, apply your mind, look at the internal dispute resolution. Is this a place that you want to be? And unfortunately, many instances do not even allow you the option to go the CSOS route, in my view. And Zelinda, you're welcome to pop in at any time. Firstly, if there's urgent relief, an interdict to prevent unlawful conduct. For example, you've got somebody in the body corporate, a trustee, a landlord, who has threatened to take the law into their own hands, to evict them unlawfully, to turn off the water. You can bring what we call injunctive relief, an urgent interdict on a rule nisi or a final basis to stop the person doing from what they're doing. CSOS can't do that, certainly can't act urgently in that regard. and the High Court would be the way to do that. That would sort of be from an anticipatory preemptive strike. If it's a complex legal issue, for example, municipal bylaws are being challenged, short-term rentals, you want to deal with issues of the management scheme that you want to contest, and you believe that you would need the information put before a judge who has tremendous power, as opposed to an ombudsman who may be localized and reticent to go beyond what the Act provides in terms of his regulatory powers. Then financial stakes, if you've got, and Zelinda, you can testify, Zelinda and I are working on a matter at the moment where we've got a developer out in Big Bay who's faced with over 2 million Rand claim for damages and for levies, and we are basically going to the High Court on that particular matter. And I won't mention that my opponent, who happens to be doing a simultaneous webinar today, is representing the developer. So that in itself is a matter that we are trying to find a way of dealing with it, either through the High Court or through an arbitration process, but certainly not through a CSOS process. Then, of course, declaratory relief. Declaratory relief is probably one of the few things that has to go through the High Court, because there you are not basically looking for financial compensation. You're looking for a judge to declare that that particular rule, that particular conduct rule, that particular aspect of the Constitution, those management scheme rules, that governance, that, you know, the resolutions taken, that it is correct that what is done, the interpretation thereof is correct, or the interpretation is not correct. And we are facing a potential situation where Zelinda and I are involved, where a certain body corporate has taken a view that the understanding of their conduct rules, the understanding of the scheme, the understanding of the Sectional Title Scheme Management Act means one thing, and we think it means another thing with regard to the EUA involved. And there we're going to ask the court, this is what the law says, this is what the trustees say, are they right or are they wrong? And if they're right, well, we're out of the water. If they're wrong, then the trustees have to carry out our interpretation of the rules with regard to the exclusive use area, etc., etc. Then, of course, the ones which are always the most enjoyable, and again, Zelinda will testify to that, if a landlord or a trustee seeks to throw out a tenant or prevents them access. In other words, they've locked the door, they've turned off the water, they've turned off the electricity because these people apparently haven't paid levies. Well, it's not up to the tenant to pay the levy, it's the landlord. But we recently had that situation, and I was called on to Cape Talk, and I threatened the trustee from doing so, and they backed off. So don't take the law into your own hands if you're a trustee of a body corporate. And then finally, if there's a ruling passed by a community scheme ombud, it's not the right one, you want to take it on review because it hasn't been done procedurally correctly, or you feel that they haven't dealt with the merits correctly, there may be an opportunity for you to approach the High Court to review that decision. Review is particularly procedurally orientated, not merit orientated, and procedurally have they considered the veracity of the evidence correctly. And then if there's an arbitration award and it needs to be enforced because there hasn't been compliance, you go to the High Court. So CSOS matters invariably may find themselves before the High Court in any event, even if you didn't want to go there in the first place. But you've got to consider, if I go High Court, invariably it's a lot more money. Is it urgent? Is it going to result in financial loss? Is it going to result in potential harm? Do we go to the High Court? Do we go urgently? Because you can't just go breakneck speed urgently. If you go urgently to the High Court and it's not urgent, you can fall on that sword. The matter can be kicked out, and you can actually have to pick up the legal fees of the opponent that you've dragged to court on an urgent basis. If it's heavy disputes, yeah.
Sorry, could we maybe just pause at that juncture, and you could just give us a bit of an idea of the timelines of the court role at the moment when it comes to urgent, semi-urgent, and all those fun things? Because urgent immediately thinks like it's going to happen within the next 24 hours, but that is not necessarily the case.
I wouldn't go on 24 hours unless my wife was standing at the airport with my child pursuant to an acrimonious divorce, about to flee to a country with no extradition treaty. How's that?
Okay.
That's urgent.
All right.
Urgency, in any event, you'd have to give at least 10 days, but my lord, you've got to prove real urgency. Patrimonial loss is usually not urgent. In other words, patrimonial loss, well, if I don't act now, I'm going to lose finance. Real urgency is threat of harm. Let me give you a perfect example. In 25 years of practice, if I've done one urgent eviction, it's a lot. If there's a bulldozer outside the trustee's property and a rogue landlord is going to knock over the property, well, that would be urgent, wouldn't it? But urgency in terms of the traditional would be maybe a week's notice, because The court roll is long. If you have a matter and it's not going to be urgent, you will be heard probably from now, I'd say about October, if not November, on what we call the semi-urgent roll. So semi-urgent is 5-6 months down the line. On the normal motion court roll where there's no urgency, you're looking at maybe a year and a half. So if it's really urgent, you can't create your urgency. But if I'd say it's relatively urgent, what would urgent be? Well, an interdict to stop somebody from harassing you. What I would do is I'd write a letter saying, please don't stop, please stop. Otherwise, we're going to approach court, but give them at least 3 or 4 days. That way, it's not incredibly urgent. They're receiving notice. And Zelinda, what I mean by that, not to talk in circles, the kind of urgency is you are sitting in your office and you receive an application to be heard that day. You've got to file answering papers by like 2 o'clock. You're in court at 4 o'clock. That kind of thing. If you go on that basis, on that urgency, if you fall on that ground of urgency, the judge is going to wrap you over the knuckles and make you pick up their costs. So yeah, I would say if you're going to go urgent, maybe 3 or 4 days, maybe a week, but never same day. Even though you can, but not many attorneys in their right mind would do so. Hope that makes sense.
Yeah, 100%. Thank you.
And obviously levy disputes, if it's money owing, it's never urgent, believe it or not. You may be owed money, for example, you haven't been paid your rental and therefore the bank's going to foreclose on your property because you haven't paid your bond. Well, then you're the author of your own situation. You can't rely on your rental to gear your bond. That isn't urgent. If, however, the bank is foreclosing on your property and the auction is tomorrow, you didn't know your legal rights. Well, that may very well be urgent in that respect. You may bring an urgent application to stop, for them to cease and desist in carrying out the auction, pending you getting an opportunity to file opposing papers. So that might be urgent. You're not the author of the urgency, but you are dealing with the application on an urgent basis. All right, moving on. So if it's going to go to the High Court, invariably the trustees obviously have to pass a resolution. You've got to get attorneys on board, choose the correct attorneys. Don't go for the cheapest attorneys, the inexpensive attorneys. Inexpensive could be more costly in the long run, but get everything together. So the type of community scheme that it is, get the government's documents together. I want to see the conduct rules, the sexual title rules, the constitution, the MOI, what type of HIA are we dealing with? I want to know everything. I even want to know who the trustees are. I want to know, is there potential any conflict? Do any of the trustees have a conflict in getting that particular attorney on board? I want to know everything. I don't want any surprises. Has there been communications, emails, WhatsApps, everything that has happened vis-a-vis the parties involved, the stakeholders involved. And I want to see everything so I can make a decision whether or not there's any problem on my side from a conflictual perspective, or if there's further information that I need, because it may very well transpire, ladies and gentlemen, that a letter may be necessary as a prerequisite to launching any application. We don't just launch. If we're going to go to court and we're going to stand before a judge, and we don't want to make our name cuck, excuse my French, we want to make sure that everything has been done to try to find commercial resolve. Not that it always can, unfortunately, but we want to see that every effort has been taken, because that may very well have an impact on the costs that are awarded. You may very well win the case because you've got a strong case until the judge says, well, Mr. Chevalier, this matter could easily have been resolved if A, it went to CSOS, even though we've got the jurisdiction to hear it, or B, why didn't you write a letter bringing that particular person to the party, giving them an opportunity to find commercial resolve? Here is your victory, you win. But there's no award as to costs. Judges often express their disdain by not awarding cost orders. Are there any CSOS rulings? Now, Zelinda, you can back me up. CSOS rulings do not serve as a precedent. I can maybe infer that there are rulings from CSOS which I can use to bolster our argument, but I can't rely on CSOS rulings to succeed in getting a court order in the High Court. I can show a previous court order in the High Court to bolster my case, to show precedent, and I can use court orders from other jurisdictions in South Africa to show persuasive influence. In other words, Judge, I know this is not a case from the Western Cape jurisdiction, it's from South Gauteng or North Gauteng or Limpopo or KwaZulu-Natal, but it's on all falls of our case. Please will you consider this case? So very important. And of course, if the case warrants the type of expert reports, and we know full well that there are a number of experts out there, quantity surveys and the like, get us those reports. If you don't have them, we may tell you to get them. The fact is you've got to put your best case before the court. If you're approaching the court with a High Court application, or you're going by way of a summons, which is a court action, best case first. I can't make my case in reply. In other words, if I bring a High Court application that there is a short-term letting issue which falls out of the realm of CSOS, somebody is transgressing it, I want to see everything. I'm not going to succeed in your case if I bring a case, I receive an answering affidavit where they say, well, Mr. Chevalier, your client failed to disclose ABC. And then in replying papers, which again costs money, I try to cure the idiosyncrasies. I can't make my case in reply. I need my best case. It may take time for me to prepare my case. We've got a perfect example now where I've got another advocate on board and that I'm using, an advocate, Michael van Staden, where we are seeking to have the trustees of a property owning trust removed. And we're seeking a declarator to declare that the trust has actually ended and they've got no powers. We've taken about 3 weeks to get all the facts together. We've traversed all the financial management accounts, the audited financials, the contingent liabilities. We've assessed the entire financial situation to show where the trustees have erred. Different type of trustees, but we've been thorough, because the minute we put it before the judge, there's going to be a set of papers coming along saying, well, they didn't tell you this, they didn't tell you that, they're talking rubbish here. Get the facts before the facts get you, and give us a timeline. When did the situation start? Whereabout are you now? What steps have you taken to find resolve? If you can't find resolve, why can't you find resolve? Can we have a without prejudice meeting? Because you can meet off the record to try to find resolve, and it's not going to find its way into a court of law to burn you. Engage the attorney at the right stage. It may very well transpire. We obviously on retainer with 300 rental agencies and 1 or 2 other big companies. And they say to us, Marlon, we've got the situation. Before that letter even gets written to the person. So in other words, before the trustees even want to deal with an issue, you would maybe go to Zelinda and say, Zelinda, don't write a letter. We don't want to make it legal per se, but give us the information that we need to pen off in a letter on behalf of the trustees to a particular owner, to a particular member. Because you may very well find that doing that on a conciliatory basis before it goes legal may actually bring issues to the fore. What I mean by that is, you may very well find that if the matter ever has to become litigious, become legal, it may very well be on a very small issue because the main crux has been resolved. Everyone's throwing the kitchen sink, but when you break it down, it might be a very simple issue that may only have to be argued either before CSOS or a court of law. It's not an emotional issue, it's a commercial issue. Courts don't want to hear about emotion. If you've got an emotional issue, put it to your psychologist. If you really want to put it to an attorney, the attorney is going to charge you for it and you'll stop doing it. But if I'm going to go to the high court, the court's not going to ask about sentiment. We're not doing a residential eviction here of children, of minors, of elderly women, of heads of household. We're dealing with a commercial transaction. You buy a property, you're bound to the governance of the community scheme. Follow the conduct rules, follow the constitution. If you don't, it's black and white, bottom line. And do not rush us, because if you do rush us, we can mess up. Rather be mindful of the fact that we work with a number of clients, a number of matters. We'll prioritize your work, of course. If you retain us, you'll be prioritized even higher. But this leads very nicely into why we have advocates on board as well. And I'll explain that to you very, very shortly. So, in fact, I'm going to come back to the costs. In fact, I think I missed the step. Let me jump up to step 6 quickly, because I think it's important to understand the role of advocates. Advocates are hired guns. An advocate might have 10 matters on the go at the month. I've got, well, in a month or simultaneously, I've got about 200 open files at the moment. I'm sure some bigger firms have a lot more matters than I do, but I've got about 200. So I'm a good juggler. But I can't dedicate myself completely to 200 matters. That's why I've got 5 other lawyers in my employ. But that's why also I bring an advocate in. It may not even be a very hectic case, but for example, with Ross Randall, who would always be my first choice community scheme advocate, I would say, hi Ross, we've got this body corporate. It's a matter falling out of section 39. It is a damages claim, the quantum is high. This is the governance rules. Here's the legislation, which you know, pat off. Here is the steps the trustees have taken. Here is your brief. I want you to have a look at it, to consider the veracity of it. Do you think we should go by way of a declarative? Do you think we should go by way of an interdict? Do you think we should go by way of an action for damages? Here's everything. They get a formal brief. And when I then go back to the trustees and say, trustees, look, my hourly rate is Rand X. I've employed an advocate. That advocate is 1,800 Rand an hour. I'm double that. My senior associates are about 1,200 Rand more than that. That advocate can devote 10 hours doing everything for a far lower fee. Give me the advice that I need and I can pass it on to you. Because don't forget, ladies and gentlemen, if you're going to high court, that advocate is the one that stands up and argues in front of the judge, not us attorneys. We're in the background. We do have the right. I've appeared in High Court. I've argued in High Court. It's not a place I really want to be. It's not my domain. Advocates, they don't want to sit and consult with clients directly. They don't want to have trust accounts and deal with all the nonsense of sending bills. They are advocates. Advocacy is a very delicate, specialized thing. They specialize in presenting arguments at court. They're involved in particularly nouveau matters. They have time to do the research, case law. That's what they study, and they prepare the legal arguments to represent you in the hearing based on the information that we have. So honestly, the use of an advocate, and you ask yourself this now, and you tell me if I'm wrong in the chat line, if Zelinda is allowing that. You tell me when you've never, ever employed an advocate for a High Court matter. Zelinda, I'd love to know if anyone has ever gone only with an attorney to a High Court. So just jumping back to the estimated timelines, I think we've mentioned it briefly. If it's an urgent interdict, really urgent, 24 hours to 2 weeks. If it's a normal application, it's going to take between 6 months and 2 years because of the backlog. There is nothing we can do about that. Even eviction applications are taking a couple of months. If it's a judicial review of a CSOS decision, that can take 1.5 years, which is quite hectic, because invariably, Linda, correct me if I'm wrong, a CSOS decision cannot be carried out pending the review one way or another. And then a trial. Can you believe it? A trial can take 2 to 5 years. Unbelievable. So attorneys have the ability to earn money for 2 to 5 years. We are very, very thankful for the backlog. Now, the truth of the matter is, because the courts are so burdened, it can take a number of years. It's just the way it is. So you also get very clever attorneys who are dilatory. They will delay matters deliberately. We recently have encountered a matter where we in Simon's Town Court, Magistrates Court, so I'm going to go and run that matter on my own because it's a Magistrates Court matter. It's going to be a maintenance trial. And basically, the woman who is the current wife of the husband, who is the ex-husband of my client, is trying to prevent the pension fund paying out a couple of million rand to my client. And they have now deliberately brought a High Court application to interdict the particular pension fund, and they've kicked into touch for like a year deliberately to put my client in a position where she can't get the money she's entitled to. We are opposing that. So attorneys can be very sneaky, myself included.
When it needs fall for it, yeah.
There you go. And then just really, and I don't mean to be patronizing or dismissive of the valued delegates, but let us do our job. We let you do your job. We will listen to the facts. We'll advise you on your possible legal action. We will give you the options. We can't tell you what to do. We can paint the pictures to you. We will ask you for all the relevant documentation. Once you've got all the facts, we will say, right, these are your options, A, B, C, potential costs, potential outcomes. You tell us what you want. If you want something and we can't give it to you, we'll say it's impractical or it's incompetent. For example, we want these people evicted today, or we want these short-term regulations not to be contested, or we want conduct rules where people waive certain rights. There's impossibility of performance, no matter who we are. If we can't do it, if the law doesn't allow it, and it conflicts with our morality and ethics, we're not going to do it for you. Go find another lawyer. If you are proposing settlement, well, there's nothing wrong with settlement. You just know about it, but settlement isn't always a bad thing, but it's not always a good thing as well. We will guide you, but you will have to make that the final decision. But the final decision, ladies and gentlemen, is an informed final decision. Trust our expertise, but be actively involved, but don't question us. Don't say, well, Marlon, I don't think you did the right thing. The bottom line is, if you ever have issues with your particular attorney, nothing precludes you from getting a second opinion. Nothing precludes you from terminating our mandate. Nothing precludes you from instructing another attorney. What I'm telling you, though, is that if I ever get a client and I see that there's been a termination of a previous attorney's mandate, I want to know why. And I would damn well phone up that attorney and ask. Because oftentimes they've terminated because they don't like what the attorney has told them. And oftentimes that attorney is correct. It's very rare that an attorney's mandate is terminated because of his expense. Because I can tell you now, I've had clients who've paid me a tremendous amount of money and gotten a phenomenal result. And that phenomenal result sets a precedent for all the people in the complex, and the return on the investment of having a good attorney and a good advocate to pronounce on a legislation aspect or a community scheme decision can have a ripple effect which is worth so much more than the cost that you've paid your attorney and your advocate. And then likelihood of success and risk. So we're moving briskly along, Zelinda, which is great.
Perfect.
The strength of the evidence, don't fabricate evidence. Don't tell us something that we want to know to make us happy. and tell us something that we don't want to know as well, because oftentimes we are not told things because the client's scared. Well, Marlon, we previously took this, we didn't have the necessary quorum, but we passed this resolution, but nobody said a thing. I don't want to hear that. In fact, I do want to hear that, but I want to know how we're going to resolve it. So always be truthful with your attorney, be truthful with the advocate. Give us all the facts, even if it works against us. You may not realize this when we are arguing a case on a community scheme issue. If we find a case that works directly against us, that's going to screw us over and not allow us to win, we've got to disclose that case. We've got to give it to our opponent. We can't hide it away because no one picked it up. We're officers of the court. Similarly, we want to know everything. If there's things you don't know, so be it, but we want to rather know the situation, because that will lead us to decide, right, are we going to spend 100,000 Rand, 200,000 Rand on a case where we know we're going to lose? We can't do that. We have to be ethical in our dealings. Is there a strong legal argument? What is their position? Oftentimes, you won't believe, we'll be guided by whom the attorneys are on the other side. Oh, we know them, they're very litigious. They've got money in their pocket and they're going to fight. That may lead us to think in a certain way. We might say, well, these people are not community scheme attorneys. They don't know what they're doing. Let's take advantage of the idiosyncrasies available to us legally to push them into a corner. Let's hit them from different sides. Let's bring interlocutory applications. Let's hit them with points in limine. Let's push them into a corner where it costs them so much money that they settle. This is what attorneys do. This is what comes with Ross having 17 years of experience and me having 25 years of experience in the legal fraternity. And whether we are strong, whether we are empowered with everything that we need, ultimately it falls upon a single judge. The judge has the discretion to make a ruling. The beauty of the High Court, the beauty of the Magistrates Court, where a magistrate makes a ruling, is there's always an opportunity to appeal. Magistrates Court, automatic appeal. High Court, application for leave to appeal. That leave to appeal, if you get granted, which means, hey, judge, you ruled against me. Do you think one of your brothers or sisters will think differently? Yes, great. You get to bring that same case before a full bench of the High Court, which is 3 judges, or you go to the Supreme Court of Appeal, which is the highest court in the land, except have the case argued there. So there's always a bit of reprieve if you don't succeed, but of course it comes with a lot more money. No attorney can ever guarantee you a victory, ladies and gentlemen. Any attorney who guarantees you success, fire them. No attorney, no advocate can, because there are so many variables that can manifest at any time, even on the day, and be realistic about the possible outcomes. All you can do is be as prepared as possible, having followed as many internal processes as possible to find resolve, and put your information in front of the attorney and the advocate to give you the best advice on how to proceed further. And I can assure you, no attorney or advocate wants to look weak in a court of law. If I don't believe the case is strong, in fact, what happens sometimes is that the trustees say, Marlon, we know that if you just bring a High Court application, they're going to buckle. They don't have money to fight this. And I say, yes, but I don't believe we've got a strong case. Yeah, I know, Marlon, just bring the High Court application. We're not going to go to court anyway. We're just going to scare them. I don't want to get involved in that, because next thing they know, they might just defend it. Secondly, I go to court and I lose and I look like a poople. I don't like looking like a poople, okay? So we don't use litigation to threaten. We don't use litigation to try and coerce somebody to come into the party. It's a nice tactic, but it is not something that I aspire to, because I don't want to use the legal weapons available to me to threaten somebody. Similar to that, you can't bring a liquidation application, believe it or not, against somebody to threaten them to pay. I don't know if you know that. Liquidation is about, well, lots of people are owed money. Let's ask the court to get what we call a concursus creditorium, get everyone together, see how everyone can get paid. You can't use as the basis of your liquidation or sequestration that somebody owes you money, believe it or not. Same thing, you can't bring liquidation or a litigation or an urgent application to scare somebody. There has to be a legitimate case, legitimate facts to do that. Obviously, not every attorney is like me. There are unscrupulous ones who will bring a whole concoction, smorgasbord of prayers for relief, hoping that one of them will stick, and maybe they'll succeed, but that's not how we work. And very importantly, as we bring this to a close, second last slide. Marlon, I want you to go to court. We'll pay you, but we want you to get your legal fees back. It does not work like that. And unfortunately, it has never worked like that. If you go to court to sue somebody for money owing, for a declarator to get relief on certain governance in the sectional title scheme, to claim damages arising out of defamation of a particular trustee, who knows, whatever the case might be. What you pay your lawyer is in terms of an attorney-client mandate. In other words, you have a mandate with your attorney for you to pay an hourly rate or a retainer for their legal services. When I go to court and I argue a case, if we win and the court makes a cost order, because the court doesn't always have to make a cost order, but if they do make a cost order, that cost order is based on a tariff of the court. The court has a specific tariff, scale A, scale B, scale C, based on the quantum involved, etc., etc. Basically, what that means is the court will say you will succeed with costs, either the generic cost order, which is party-party, in other words, the court's tariff on the lowest scale, or attorney-client costs, which means it's the same tariff, but for more attendances. In other words, more work that was done, which goes a little bit beyond what the tariff provides in terms of attendances, and then punitive costs, which would be everything that your attorney has charged you, but on the tariff. There's lots of debates about what attorney-client is, attorney-owned client. The long and short is that if you win with costs, you're not going to get just paid those costs, and you're certainly not going to get your legal fees back. If you get 50% of the legal fees you've paid your own attorney for winning a case in court, you've done exceptionally well. To get those fees, you've got to draw a bill of costs. That bill is put before a taxing master. The taxing master goes through it. The other side gets a chance to oppose it. He eventually says, right, your legal fees may have been 100,000 Rand. Your bill of costs comes to 50,000 Rand. I'm stamping it. You get 40,000 Rand. That stamped bill of costs is a court order in itself, and you can sue or execute on that bill of costs. Doesn't mean that the person's got money, but that is how it works. Bearing in mind that legal matters is not about making money. We don't have a punitive system in South Africa like we do in America. You slip on the floor at Walmart, you can sue $100 million for punitive damages and actual $5,000 for damage to your knee. We don't have that. You can't make money off litigation in South Africa. But getting a court order may have a far more gravitas effect than the money you've spent in order to ensure that you've got uniformity in your community scheme. So that's it. Costs are not readily available. It takes months before you potentially could even pursue those costs before a taxing master or a taxing mistress. And then the possibility of not even getting anything after that is very probable. And finally, not everyone abides with the High Court judgment. You get a High Court interdict, you get a rule nisi, you get your final order, or you sue somebody for 2 million Rands worth of levies, or any other type of application, a declarator. You've got to honor the judge's interpretation of the conduct rules, or what the Sectional Title Scheme Management Act says. A fellow owner, a fellow trustee doesn't honor it. Well, then you can always approach court for a contempt of court application. Say, hey, judge, we brought this application. It was opposed. We succeeded. We've got a final order. They haven't complied. Here's a letter calling upon them to comply. They haven't complied. Hereby we're bringing an application to compel them to do so. And if not, and they don't comply subsequent to that application to compel, you can actually ask for a custodial sentence. You can actually have somebody imprisoned for contempt of court. But rather what you will have in the situation, the judge will confirm the application to compel, penalize them financially for not doing so, and as last resort, potentially even incarcerate them. Last kind of resort, we've only had that happen once or twice in a couple of years that I've been around. If you sue somebody for millions worth of levies and they don't pay, you get a judgment against them. If they don't pay on judgment, you execute against them. You go after their movables. If necessary, you go after their immovable property, etc., etc. And of course, if it's a situation where they haven't got anything, you may eventually have to bring a sequestration application or a liquidation application. I'm not saying that's always your first port of call, but if you owed a fortune of money and there appear to be other creditors owed money as well, liquidation or sequestration may be the way to go. And I think those of you who have been involved and who are managing sectional title complexes, you would know full well, if you execute against a movable asset and there's nothing, and you then, in terms of the Magistrates Court, Section 66, you execute against the immovable property, you know full well you can sell immovable property in execution, and you know full well that if it comes to the worst situation, if that unit in a body corporate is owned by a closed corporation or a company, you can potentially own in somebody's personal name, you can potentially sequestrate. Many ways to skin a cat. That is actually my time. I don't know how we're doing for time, but
We still have 15 minutes, so we can maybe open it up for questions. Thank you so much, Marlon. It's interesting for me to hear. I mean, we obviously are not litigation attorneys, which is why we work so great with you, as well as a couple of our other colleagues. But, you know, the taxation of costs, I mean, people think that when they're dealing with litigation and they get a cost order, like, yay, we're getting our money back. And then you tell them, well, you're only going to get a percentage of that, provided the taxation happens. But then the thought is, okay, fine, now I've got this order from the taxing master, and I haven't heard the term mistress yet, so called taxing mistress. But you would still maybe even need to incur further legal costs to go and get those legal costs. It's like a never ending.
Just stop it. You're spending legal fees to go up to court fees. I know.
Crazy.
It's throwing good money after bad. But again, that's why I emphasize, firstly, you're spot on. I was hoping you wouldn't ask that, because people say, but Marlon, what we do is we've got a cost consultant. Her name is Gwen Lakay. Gwen is a bill of costs expert. So what we do, what's quite lovely actually, is she says, hi Marlon, how can we help you? I say, right, this is the file. These are our attorney-client fees. To give you an indication of the work that was done, this is our cost order. Either it's party costs or attorney-client costs or whatever. Now it's on a punitive scale, A, B, or C. It's all changing at the moment. And we say to her, please, will you prepare the bill of costs? So what she does is she takes the files, she takes our bills, she looks at our tendencies, she takes the court tariff, and she draws actual bill of costs. Receipt, 84 Rand, 84 Rand, cost 6 Rand a copy, blah, blah, blah. She draws the bill of costs, and what she does is she charges us 10% of the cost of the bill. So the bill comes to 80,000 Rand. She would charge 8,000 Rand. It might take her 10 hours to prepare the bill. It's not going to cost you that. We don't charge. We get it. We give it to her. She handles it. She also has the authority to go to the taxing master herself and argue on that bill of costs in itself. Again, you don't have to incur legal fees. Some lawyers like drafting the bill of costs themselves. I don't like it. But the nice thing as well is Zelinda, is that we sometimes say, here's the bill of costs, ladies and gentlemen. Can we agree to the costs? In other words, here's the bill of costs. It's 80,000 Rand. You might get 20,000 Rand off. It might be 60,000 Rand. If the attorneys have to go argue and it's going to take a long time, I tell you what, put 50,000 Rand in our trust account. Let's call it a day. Rather have 50 in your bank account and the potential of only getting 60 6 months down the line. So there's a lot of horse trading going on.
I know Razine was quite eager to ask you a question or to get your view on the matter. Razine, you've unmuted yourself. Go for it.
Yes, Marlon, I actually wanted to ask you, and this is something I've been meaning to ask you for about a week now, so it's good that we're having this webinar. But have you ever dealt with an administration application? Perhaps an owner's brought it against the body corporate. And how does that proceeding go? Would you advise it where, you know, sometimes trustees are fighting with each other, the scheme ends up suffering financially as a result, the managing agent doesn't know what to do?
Section 74, isn't it?
I'm not sure. I believe so.
The bottom line is this, is that it might not be Section 74. I did one a while ago. The only problem is once you place an administration, you take it out of everybody's hands, you put it into the hands of a receiver, you actually lose control of the body corporate. If it is in such a dispute, Zelinda, remember that one we had in Clifton, where, you know, in that particular instance, it's not the first call. I think if you reach a situation where there's such internal disputes with the trustees, there can't be a quorum obtained, the entire substratum is being affected, the owners are being affected, no resolutions can be taken for the progress. In other words, insurance is going to be compromised, the veracity of the entire complex is going to be compromised, then you might have to put yourself in the hands of a receiver, which would be an administrator. But I would think it would be a last port of call, in my view. 100%. It has to be irreparable damage to the body corporate or to the HOA before you go ahead with an application for administration, which of course can be opposed. But you're basically saying, you know what it's like? It's not dissimilar to putting a company into liquidation. You're taking the company, 100%. Alternatively, you've got two partners, two co-directors, I should say, two shareholders in a company. There's a conflict of personalities. There's no power of veto. You say, look, I'm going to blow it up. Put ourselves into the hands of a receiver. They will decide how the shares are to be disposed, etc., etc. It's actually very analogous. I'm sure you can find on the internet the analogy between an administration of a BC versus a liquidation of a PTY Limited. etc.
Interesting blog post idea, Rosie. Jump on that.
Thank you.
So it also depends on who the administrator is. I mean, we work very closely with Vili's team from Stratif and the Confiance guys. And, you know, it's amazing what they're able to do in a body corporate. But unfortunately, you do get administrators that are there for the control and the money that comes from it. And you simply cannot get rid of them when the scheme no longer needs them. So an administrator should be like a mergers and acquisitions guy. They're in, they sort things out, and they're out. As opposed to just, you know, leeching onto the body corporate for years and years. Lachey, you had your mute off for a minute or two there. Sorry, I had to mute you. There was some background noise. Is there anything that you'd like to add? Lachey, for those of you that don't know, was a managing agent,
Awesome.
studied law for 110 years, and she's just finished writing her last examinations, and I think she's got like a couple of weeks left of her, what do you call it when you work with an
Articles.
advocate now? And she's going to be a fully fledged advocate herself, or is a fully fledged advocate.
Pupillage, okay. Very nice.
Hi, Zelinda. Sorry, I came in on my cell phone. I didn't realize it was unmuted. So no questions from my side. No.
Okay.
Sorry.
Well, then you got a bit of a sales pitch, so there we go.
Thank you so much.
I remember dealing with you, must have been 15 years ago at Hodgson Property. Crazy. Time just flies.
Yeah.
It was a while, Marlon. It was a long time ago, but time flies when you're in this industry. Hey, you either love it or hate it.
Yeah.
Well, welcome to my world. I can tell you that. Welcome.
Thank you.
So we've got a couple of questions on the chat. The first question was, would you consider illegal installation of solar panels on the common property roof by an owner as being an urgent matter?
No. On what basis would it be
Is
urgent?
it an urgent matter, or would it go on the normal roll?
Well, if you're going to bring an application, any type of application you seek injunctive relief, you've got to be able to show at least three things: irreparable harm, no alternative remedy, and there's irreparable harm, no alternative remedy, and there's a third one, a potential injury to life or limb. So I think there's something else, but it escapes me now. Basically, the court says, well, let's look at this. Is there urgency? What urgency is there? Solar panel illegal? Who's suffering? Yes, there may be somebody who's benefiting from the installation. That can be quantified in damages, can it not be? And that in itself is an action which certainly is not urgent. Secondly, is there irreparable harm? No, there's no irreparable harm. Semi-urgent, I wouldn't even say. I would just say it's a formal application that they failed to do so. And you would ask for what we call a positive interdict, which says you are compelled to remove it, failing which will approach the court to give us an order whereby the body corporate can get their own choice of electrician or solar guy to remove it, and the cost occasioned thereby would be for your attention. But no, it wouldn't be, because certainly that is a loss you can quantify. If, however, you've been locked out of a property, well, that would be urgent, because where are you going to stay? But then again, I could come to the counter argument, well, you can go stay at your cousin, twice removed. So maybe it's not urgent. But solar panels illegally installed is an illegality, but any illegality doesn't automatically make it urgent. So it would be no alternative remedy, irreparable harm, at least those two factors. Maybe coming with a third one, or Rizal can.
Maybe with the Rizal's actually in the air at the moment. He's flying from the UK to Cape Town. He would have loved to join the webinar. Razine will give you a moment or two to think about it. Maybe if you think about that Vodacom situation, that building in Cape Town, that they had so much solar and all that fun stuff, it was a structural impairment or a fire or something along those lines, but very interesting nonetheless. Here's a nice rental one for you, body corporate rental. So good day, can a tenant forward his or her dispute to CSOS if the rental agent or landlord are I assume they mean forward their responsibility repairs to the tenant. So like a delegation question. No.
Got you. Rental is rental. Rental is before a rental tribunal. Any landlord has the dereliction of duties. You certainly want to either be brought before the landlord in terms of the rental housing tribunal. And of course, if it's a property practitioner, that would be the PPRA. That actually takes us back to our original webinar where we spoke about the role of rental agents for individual units in a sectional title scheme, which is managed by trustees who appoint their own sectional title agents.
Yeah.
There's too many agents in the mix.
The next one is: a year after an acknowledgement of debt was signed, 20,000 Rand of lawyers' invoices were added to my levy account. Is this the correct process? Should they have been taxed?
Should have been taxed. No attorney can add their own attorney-client fees onto an AOD. And it's a very simple reason why. An acknowledgement of debt is between a creditor and a debtor. The attorneys are not a party to that agreement. The attorneys look to the creditor for payment, and the creditor may seek payment of whatever they've paid from the debtor. but it can't be attorney-client legal fees because the legal fees incurred is between the attorney and the creditor.
Perfect, 100%. And in terms of the STSMA, unless the owner agrees, which they're not likely to do, or there is a court or an adjudication order, you can't add legal fees. The next is, can I sue the body corporate for loss of value of asset because there's no financials, no maintenance, huge arrears, and general unprofessional management of the complex?
If you can prove a legal connection, a causa, between the actions or inactions of a body corporate and your devaluation, certainly it's a tough one. So what you're saying is that because of the malperformance of a body corporate or the trustees, you as an owner have hypothetically been unable to sell your property for the value for which it is worth had it been maintained properly. You're able to show the value of your property now as opposed to the value of the property it would have been or would have achieved on a valuation had the body corporate done the job. That residual, that differential between the two could actually be a potential claim for damages. I would say so. I'd fight that.
Yeah. We've got another 5 minutes left, so there's one or two more questions on the chat and then we can open up the floor. Given the cost involved when the body corporate is involved in high court litigation matters, should the body corporate provide for same on their balance sheet? Now, I'm not an accounting fundi, but you do have to have a budget before you incur legal costs as trustees, so there has to be a mandate from your members. Any comments on that?
No, absolutely. But I think it's also important to remember that as long as there's a resolution, as long as a special levy can be raised, there's got to be a budget. But I think that deals with at the inception. That's this whole 10-year plan and fish paste and whatnot. But I mean, litigation, is it an expected expense? I think you need to budget for potential expenses. You need to have money in the kitty, surely, Zelinda. But whatever you do, you've got to make sure you have the necessary resolution.
Yeah.
And I think if you look at that current matter that we're dealing with in Big Bay, the resolution that they obtained in order to instruct attorneys to do what they had to do, they had money. They haven't had to raise a special levy, from what I understand, to cover our legal fees. So yeah, you have the budget, but also make provision, I think, in anticipation, because it's a contingency that may never arise. And you just keep it and you allocate it towards other non-luxurious expenses.
Yeah. It makes me think of another matter, a homeowners association that we were both involved in, where the trustees did embark on legal action because they were forced to. The other side made the original application and they did have a budget for legal fees. But before they could continue with the legal action, a meeting was called with the members and the members directed the trustees to not incur further legal costs. So having the budget is not the be all and end all. And of course, the members do have the ultimate say, but members sometimes make uninformed decisions when they don't have all the facts on the table. So if you go to a meeting and you have the idea of, the legal fees the body corporate should be spending, that means I'm going to have a special levy raised against me, etc., 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 you might put the scheme in a situation where they've got legal action taken against them that they are not in a position to defend. Have you ever dealt with a situation, Marlon, where, the trustees have been cut off at the knees by the members, where, what happens in that instance? What happens when you don't have the authority to defend? I mean, surely the court just makes an order in your absence?
Yeah, but it's just to mention the one slide I did miss, maybe it was fortuitous, is what kind of fees you're looking at. So everybody can just have a stiff drink and then have a look at that. I think what's important to remember is that obviously we can only act on instructions. We can only act on the instructions of the trustees. The trustees must sort out their own internal governance to ensure we've got that. Just because if we hypothetically cannot act any further because we've got no instructions, because the members have taken a stance that they must not pursue any litigation, that doesn't mean that any applications or action that has been launched will desist. They will continue. They will continue on an unopposed basis. But similarly, it doesn't also mean that you might have a judgment against you. The court has an obligation in law to consider the case before them. And just because people are unrepresented doesn't mean they'll make a finding in your favor. It's more probable that they will. For example, if I bring an application to court which is unopposed, I'll probably get judgment. If I bring an application to court which is opposed, but there's no one on the day to appear for argument because their mandate was terminated, that judge will still take cognizance of the papers filed of record. He may very well call some witnesses to come testify to those facts. So it can't be an assumption. And I have been involved in that situation before, and I can tell you what really does happen when hits the proverbial fan. Those members who called a halt to the proceedings are the ones jumping up and down. Now we've got a judgment against us. What do we do? Well, in that instance, you're the author of your own situation. You try to save legal fees, not realizing the gravitas and the effects of a judgment against the whole complex as a whole. In fact, you may very well find that the trustees might have a counteraction against the members for calling a halt to the legal action, because now they're all suffering in one big common pool.
Crazy. We've got 2 minutes left, and I know that there's a couple of people that want to hop off to join the West webinar. There's been a couple of very interesting questions that have been raised, one or two more on the chat, which we can take a look at afterwards. Just a reminder that the recording is going to be placed on our website, along with that case law that Marlon mentioned. Sorry, a copy of the slides, as well as information relating to Jules and the Backer Buddy there. If you have any questions in that regard, please feel free to reach out to us. I've also shared Marlon's contact information and his rental club, rental retainer club. So a really great platform to be on. And Marlon is super, super quick to answer questions. I don't know, Marlon, if you want to take 30 seconds just to tell us a bit more about your club.
Quick thing I just want to mention is the third point was balance of convenience. Irreparable harm, no alternative remedy, in the balance of convenience favors one or the other. Yeah, my rental retainer club, thank you. That's different to what we are talking about today. In simple terms, for the last 11 years, I've provided on-tap residential rental property legal advice. I currently have over 300 agencies who pay me 550 Rand plus VAT a month. They get 2 hours of my time every month for written responses to landlord-tenant questions. I get it from sectional title agents as well. And they get a free newsletter every month. They get discounts on rent collections, on evictions throughout the country. They basically have me as their buffer, because rental agents are expected to know the law. They don't know the law. They don't have LLBs, although Lishay is someone in his exception. And the fact is that I step up with my legal expertise and I guide landlords on how to educate their tenants, maybe even how to deal with sectional title agents. And every single month, I'm available to give you the best priority advice. Go to our website, rentalretainerclub.co.za. You'll see all the agencies who are members. You might find yourself being a member as well, or one of your branches is a member. And it's the most no-brainer. I've got an email with testimonials, what we offer, everything. And it's all in one email, and check it out. And you can give a month's notice at any time to leave. So
fantastic. I don't know about anybody else, but I recently took a couple of kiddos to the movies, and just getting some movie tickets, popcorn and Coke cost me over $500. So yeah, it was, I'll definitely keep the club in mind as opposed to taking the kids to the movies. Ladies and gents, thank you so much for joining us. If you have any questions, if you'd like to reach out to Marlon, please feel free. If you'd like to engage with us, you know where to find us. Don't forget to join us at the Let's Get Physical event on the 5th of March. It's happening at the Century City Clubhouse. And I've shared information about our next webinar that we are going to be chatting with Vili from Stradivin and Puna from Meeting Pal. That's happening on the 27th, I believe I posted. And then, of course, we've got the Engage event coming up towards the end of the month as well. Marlon, you are a panel speaker there, and we're going to be in attendance as well. So looking forward to that. So much going on over the next 2 months. If you would like any of those dates registered for any of the events, contact Kyle, info@tvdmconsultants.com. And until our next webinar, have a fantastic day, a good Friday, and a lovely weekend. And we'll chat to you all again soon. Thanks so much, everyone. Thank you, Marlon, for your time.
Thanks, everybody. Have a wonderful day further.
Really enjoyed it. Keep well. Bye.
Bye. Bye-bye.